What exactly is a bill of attainder and why is it illegal? In this video, we're going to dive into this lesser-known but incredibly important aspect of the U.S. Constitution. We'll explore what they are, why they matter, and how they protect us from government overreach. On February 25, 2025, President Donald Trump signed an executive order targeting the law firm Covington Burling. The order revoked security clearances for attorneys at the firm and cut off its access to government contracts. Covington Burling had previously represented Jack Smith, the former special counsel who led criminal investigations into Trump. There is a strong case that the order is unconstitutional, punishing the firm for providing legal representation rather than for any wrongdoing, which we will explain today. That claim rests on a crucial but often overlooked part of the U.S. Constitution, the prohibition against bills of attainder. It's not a term that comes up often in everyday conversation, but it's one of the most important protections against government overreach. A bill of attainder is when the government declares someone guilty of wrongdoing and punishes them without a trial. The Founding Fathers wrote this prohibition into the Constitution to prevent exactly what they had seen in British rule, where the government could single out political enemies and strip them of their rights by decree. The idea is simple. Punishment in America requires due process, meaning a fair legal process, not just the stroke of a pen from a president or legislature. Now you might be thinking, wait, isn't a bill of attainder something Congress does? Can a president violate this rule with an executive order? That's a good question, and it's something courts have wrestled with before. While the Constitution specifically prohibits Congress and state legislatures from passing bills of attainder, courts have also ruled that executive actions can function in the same unconstitutional way if they single out individuals or groups for punishment. The question here is whether Trump's executive order was a neutral policy decision, or whether it was a form of retribution against a law firm that happened to represent someone he sees as an opponent. To answer that, courts rely on three key tests. First, does the action target a specific individual or group rather than setting a general rule? If the government passes a law or order that applies to everyone, it's usually fine. But if it names a specific person or company and punishes them without a broader policy rationale, that's when red flags go up. In this case, Trump's order explicitly names Covington Burling rather than applying to all government contractors or all law firms that have represented prosecutors. That's one sign it may be unconstitutional. Second, is the action punitive? The government has the power to regulate businesses, but if a law or executive order is intended to harm rather than serve a legitimate purpose, it can be ruled unconstitutional. Courts have repeatedly said that excluding someone from government work can count as punishment. In past cases, the Supreme Court has struck down laws that blacklisted individuals from government jobs simply because of their political affiliations or past actions. Here, the fact that Covington Burling is being cut off from government business and that no other law firms are facing similar restrictions raises serious questions. The timing of the order, coming after the firm represented Jack Smith, also suggests this wasn't just a routine administrative decision. Finally, courts look at whether the targeted person or group has any way to challenge the punishment. Due process means you have the right to defend yourself, to argue your case, to present evidence, and to appeal a decision. If the government punishes you and gives you no way to fight back, that strengthens the argument that the action is a bill of attainder. In this case, Trump's order provides no avenue for Covington Burling to contest the decision. They weren't accused of any wrongdoing and there was no hearing or judicial review. The order simply cuts them off, with no recourse. That's another serious constitutional concern. So can a president use executive power to punish political opponents? That's the fundamental question raised by Trump's executive order. If the government can strip away security clearances and cancel contracts not because of wrongdoing, but because of who a person or business has represented in court, where does that line stop? What prevents future administrations from using executive authority to blacklist lawyers, journalists, companies, or private citizens simply for being on the wrong side of political power? The Constitution is clear. The government cannot impose penalties on specific people or businesses without due process. The founders wrote the Bill of Attainder clause precisely to stop this kind of unchecked power. Without that protection, Any administration, Republican or Democrat, could bypass courts altogether using executive orders as a tool of personal or political vengeance. That's why this case isn't just about Covington and Burling, or even about Trump. It's about whether we, as a country, are willing to accept government power being wielded this way. Maybe you support this particular order because you don't like the people involved. But what happens when the same logic is used against someone on your side? The law is only as strong as our willingness to apply it consistently. If this order stands, it sets a dangerous precedent. If it falls, it reaffirms a core principle. The president is not a king, and punishment in America requires more than political decree. Courts may soon weigh in, but the public conversation matters just as much. Understanding the law, rather than accepting simplified partisan narratives, is the only way to hold power accountable. So read, question, and think critically. This case is about more than a law firm. It's about whether we're still a nation of laws at all.